Good evening. My name is Carrie White, and I'm very glad that you've joined us. I am the Marie Program Coordinator, and it's our grant who is hosting these webinars for you. I have some housekeeping items, and would you please listen closely as some of the instructions that I sent you earlier today have changed. Captioning and interpreters are provided. The streaming window opens automatically. There is a tab for audio and video on the far right. Click on the button corner and a menu will drop down. Click Detach Panel. Then you can resize the video box. To open the captioning, click on the captioning icon on the toolbar. Windows can be closed or sized to create your personal viewing environment. The chat window can also be made bigger by pulling it out. To do that, click on the icon box in the upper right-hand corner of the chat box to access the menu and make the chat font bigger. If you have technical issues, use the chat function and a member of the Clearinghouse staff will aid you. Questions for the presenter tonight are to be put into the chat function. This is where we have a change from earlier today. With such a large audience, we are asking you to write down your questions there at home and then wait for Carla to ask for questions. Then at that time, you may type them in the chat box. After the webinar, I will come back on. I will have some other conclusion statements to make and talk about CEUs and our listserv to come up, so please don't exit out too soon. Now I'd like to turn everything over to our amazing presenter, Carla Mathers.
Thank you, Carrie, and welcome everyone. It's amazing, there are actually 109 of you, and the good thing is that you can't see that I'm sitting in my pajamas. I'm not used to webinars, I'm used to teaching in person, so this will be a new experience for me. I want to do one thing right at the beginning because I don't know if people read the instructions carefully, but in the legal interpreting field, in our niche area, it's practice to present our presentations in American Sign Language. As you can see, we're not doing that today, and it was explained in the email that went out in the instructions. But because we're archiving this, I want to make sure that it's also stated. For the reason why we're not doing it in American Sign Language is this particular platform isn't conducive to it. My understanding is that will be changed this fall so that the next platform that we'll be using after the summer series is concluded, we will be able to present in American Sign Language. So I know that there are deaf people on the list. I saw that, and I apologize, and I wanted to put that out there right in the beginning. So Carrie was correct. I'm going to go through this presentation, and at predetermined times we'll have an opportunity to have some discussion. Given that there are 113 of you now, we obviously won't get to all the questions, but I do want to have some interaction. Today we're talking about legal interpreting basics, and that's maybe somewhat of a misnomer for this particular topic. It may be misleading because what we're really talking about is what are the competencies and skills required to be a legal interpreter. So it's more of an overview of the kinds of things you need to know and the kinds of things that the Marie Center and through our legal work group for the past 7 or 8 years have surveyed the profession, and we believe that there's a consensus on. So we do know that in the United States, court and legal interpreting has long been an area of specialty interpretation and specialist practice. It is the only specialty examination that is currently being given And if I'm wrong on that, I'm sure somebody will remind me. Yet, we did a survey with the NCIEC and found that most interpreters, even though they want training, they don't do a lot of legal interpreting. So we were wondering why. I mean, is it too scary? Is there too much at risk? Is it perceived as having too much liability? Are there other market forces at work? We talked about the complicated structure and the meaning of legal language being very difficult to access if you're not repeatedly exposed to it. We talked about the substantive and procedural processes that interpreters encounter in court and the various legal proceedings. And it was felt that these particular items posed great challenges to practitioners. So interpreters need to know how to get the knowledge and skills necessary to function effectively within the court and legal systems. And these are items that create challenges for practitioners. So that's what we're going to talk about today, the various knowledge areas, the skill, and the conduct rules regarding interpreting in legal settings, those that make it very daunting. So as you know from the handout, we're going to talk about legal interpreting and distinguish it from community interpreting or other legal interpreting settings. We have 5 assumptions and or core values associated with interpreting in the legal domain as a specialty. We're going to describe the steps that generalist certificate holders can take to obtain the necessary skills to sit for the specialist, to sit and successfully pass the specialist examination. And then also we'll identify the major resources that are currently available to people who are looking to work in legal settings. The term community interpreting comes from the spoken language tradition, spoken language interpreting tradition. They differentiate community interpreting from diplomatic interpreting or conference level interpreting. You might hear it called a number of different things in other countries. In the UK, they call it public service interpreting. In Canada, they call it cultural interpreting. I've also seen the terms ad hoc interpreting and dialogue interpreting used. But essentially, community interpreting enables speakers of different languages who are not fluent in whatever the official languages of the country to communicate with providers of public services so that everyone has access to legal, healthcare, educational, government, and social service settings. So there are some characteristics of community interpreting that they tend to mostly occur in institutional settings. They tend to be interpreting dialogues as opposed to monologues. Interpreters who work in community settings routinely interpret both into and out of all of their working languages. The presence of the community interpreter is also much more noticeable in communication settings than with diplomatic or conference interpreting. Conference interpreting, we know they're sitting usually in a box away, and they're not right there in the interaction and to some extent participating in the interaction. One other difference is that community interpreting usually happens in many different languages, whereas diplomatic or conference interpreting happens with those few kind of lingua franca languages that are used at international conferences. That's community interpreting. Legal interpreting is a very broad category, and it includes both quasi-legal and court interpreting. According to Gonzalez, The Fundamentals of Court Interpreting text, legal interpreting refers to interpretation that takes place in a legal setting such as a courtroom or an attorney's office, wherein some proceeding or activity related to law is conducted. That could be just about anywhere. I'm sure you all have examples. But as we often say, legal interpreting is all interpreting can be legal interpreting. But we generally think of it as somehow related to attorneys or officers or the court. But there's also quasi-legal interpreting. And that's a setting, any setting that has legal implications. So you might be going to the Department of Motor Vehicles, and you might be interpreting for an administrative hearing there if someone contests the ticket. Much employment law or employee relations deals with the law. You might interpret a sexual harassment training or seminar. That's quasi-legal interpreting. And then there definitely is a tremendous overlap between mental health, and legal interpreting. Court interpreting is a very small subset of legal interpreting. Its rules, its ethics, and its protocol are established by the court, oftentimes by committee, often in consultation with spoken language interpreters, with bilingual attorneys, with judges. So it's a different setting for us because we're used to setting our own rules through our professional association, drafting our own ethics, and deciding what is and is not ethical ourselves. But with court interpreting, that function has been taken by the court. So the ethics are different, and they sometimes conflict with the Code of Professional Conduct. There are protocol differences, meaning how you act, how you conduct yourself as an interpreter. There are substantial preparation obligations, and there are also substantial barriers to obtaining preparation materials. And we are governed, as I said, by the ethics, but also by various legal theory that has been used over the years to interpret how all language interpreters should function. So we start with the definitions. As a specialty practice, there are assumptions or core values that legal interpreters maintain, and I'll go through each of them. These assumptions were based on some of the work done on the entry to practice competencies by Wintermatthew and Johnson in 2005. We looked at what was required for a generalist and what were the core values that we felt applied to legal specialty settings. So a competency means having the requisite foundation in interpreting competence for the setting that you're working in, either in a high-risk or in a low-risk setting. Low-risk settings are those that involve routine and predictable activities that allow the parties sufficient time to interact and to negotiate meaning. Generalist interpreters are defined by the CPC, by their continuing education, and now by post-secondary degrees. So the first assumption for legal interpreters is that generalist competency is the prerequisite foundation for specialization. So that means that the legal interpreter is a competent generalist across a wide variety of settings in a range of low to higher risk interactions. Assumption number 2. An established generalist practice is a prerequisite for specialization. So you have a well-rounded base of practical work experience, and that takes anywhere from 3 to 5 years of full-time work and experience to accumulate. Because you have to develop that experience in a broad range of low-risk settings with a broad range of consumers, and you have to develop a foundation for judgment and professional ethical decision-making. Assumption number 3, a period of supervised work experience is an essential aspect of induction into a specialty practice. So that means working with experienced and recognized specialists, working with a mentor, working with a colleague, collaborating over a substantial period of time, usually a year, undertaking observation and supervision discussions, deepening critical thinking and reflection, allows the specialist then to be able to work autonomously in specialized settings. And it also fosters collegial collaboration, which is something that is a characteristic of legal interpreters. So assumption number 4. Specialists regularly engage in collegial, I can't say that word, so we're just going to stop saying it, in the exchange and conversation with colleagues and peers for the purpose of ongoing reflection and evaluation. The cornerstone to creating an ethical practice is to be able to engage in reflective practice, to think about the work that you were doing, to be peer-reviewed, not to work alone or work in secret, but to have colleagues watch your work and reflect on it. It requires self-awareness, and it always requires assessment, both internally of how you are interpreting and externally with your peers. Assumption number 5. Specialists sometimes work in teams, and one member of that team is often deaf. Legal interpreters believe that certified deaf interpreters are essential to the effectiveness of many interpreting teams, particularly when the linguistic and cultural demands require the competence of a native user of ASL or a specialist. So those are the 5, what we're calling assumptions and core values. And at this point, we're going to see if there are any questions. So if you've had questions, please feel free to put them in the room, and I'll give you a moment to do so. Okay, so we're seeing all the technological challenges, but does anyone have any questions about the competencies or the assumptions and core values that we just discussed? Okay, this can go either very quickly or not. Well, I see a question, but it wasn't to me, so I'm not entirely sure, Lara, you wanted to talk about. Yeah, there you go. Okay, that was a private question. Teresa asked, if there are not many SCLs in the area, where do you suggest we get feedback? We'll talk about it a little bit later, but there are a number of resources that you can use. There's online discussion groups. There is an 18-month online training program. And there's trainings like these today. I need to look at your question one more time. And if there are not many SCLs in your area, most likely there are people who are experienced but who have not yet taken the examination. So you find out who's doing the court work in your area, or then do some of the other techniques that I mentioned about getting maybe an online mentor. I know a couple of people who live in California and do mentoring for people in New York City, because you can do it through private YouTube videos. So there are ways. I mean, it's more difficult if you're in a rural area. Right. So, Kirk, I'm going to go through actually what's required to sit and what they test for the SCL towards the end of the program. So I can give you those ideas then. And I'm not entirely sure that Pennsylvania offers a certification. They do require that you take a 2-day training and that you be registered with the state and licensed with the state. I'm not sure which it is, before you can get on their rosters. But they do have a roster, and that's a good way to find out who's been interpreting. Jerry Ann asked a really good question. Does the supervision need to be with another ASL interpreter, or can it be with another legal interpreter who may use a different language? There are a number of practices that are similar with spoken language interpreters, and there are a number of practices that are very different. In particular, many spoken language interpreters, the first place they work is court, because there isn't, until recently, there hasn't been a market for them to obtain paid experience. So our training is different, our education is different, and so I would have, if I went with a spoken language interpreter, I would ensure that I located someone who is federally certified. There are different tests, state and federal tests. I would get a mentor, not only who might be a spoken language interpreter, but I would have a deaf mentor for language issues, and ideally a CDI who works in court if you have access to one. Well, if not, a DI who's interested in interpreting. And then the third kind of mentor you typically want to talk to is someone with legal knowledge. And as I was getting ready to start it, I wanted to give a shout out to like the 12 attorneys who are already in this class, or people who are prepared to take the bar exam. So there are a number of resources out there, and at the end of the day, I have some websites for you. Right, and Carrie mentioned the legal interpreter training program offered by the Marie Center, which is the 18-month courses class that culminates with a mentorship. I would talk about some of, Nicole asked about specifically in the courtroom ethics change. Will I be providing some examples? Probably. Because a lot of what I'm going to go through is what knowledge and skills you need to know to do legal interpreting so that you can follow up on that by taking proper courses. One of the things that we know at the Marie Center is that there simply isn't enough time in a 4-day class, in a 2-day class, in an hour and a half webinar to tell you exactly what it is you need to know. We can guide you and give you resources and tell you the general areas, but then that work is going to have to be done because it's extensive. Okay, we will, I see a lot of private messages, let's see. Okay, great. So we're going to move on now to talk about the legal interpreting competency domains. What areas or domains, which are areas of knowledge, do you need to know in order to work in court or legal settings? So competency domains, generally, we have competency domains for a generalist interpreter, things like theory and knowledge, academic foundation, and world knowledge to effectively interpret. Another category is that of human relations, being able to get along with the people you work with. Language skills, obviously relating to the use of ASL and English. Technical interpreting skills, which are those technical competencies that need to be mastered in order to be effective as an interpreter. And professionalism, which is associated with the RID and standards of practice. So in legal interpreting, from the research that the legal work group did for the Marie Center, we came up with these particular competency areas. So court and legal systems knowledge, knowledge of general legal theory, a broad understanding of general court protocol, and I will give you examples of that, court and legal protocol. An interpreter needs to demonstrate the knowledge and skills for effective decision-making while interpreting, so the interpreting skills. And demonstrate competencies critical to ongoing professional development within court and legal settings. I'm going to go through each of these and give you some specific examples. But in regards to the last one, professional development, the RID recognized, it was actually the legal interpreters who recognized the need for ongoing continuing development and training because it's not an easy area to learn. So people who hold the SCL are required to receive 2.0 hours, CEU hours, per cycle within the field of legal interpreter training. And the Marie Center, and I think Diane Fowler's on the list, I saw her name pop up for many years, provided a triennial training called Iron Sharpens Iron, and that gap has been filled now with the Marie Center and with the grant that we are required to provide legal interpreting training so that people have an opportunity to get those 2.0 CEUs. All right, so the first competency area is knowledge of court and legal systems. Obviously, you have to have a general understanding of the American legal system and its complex system. We have a federal system which governs all 50 states. You might find yourself in the federal system if you are interpreting a discrimination case for a deaf person. We also have 50 state and the District of Columbia systems of the judicial system, but there's also, and those obviously govern whoever is in your state, but then you have local. You might have local courts that you're in or county courts that you're in. So you need to have a general understanding of how the legal system is set up and how it works. You also need to understand the difference between procedural issues or procedural law and substantive law. So procedural means the procedures or the processes that are followed. Are you interpreting an arraignment where a person is informed of the charges against them and some other rights? Or are you interpreting a trial, right? So procedural law. Substantive law is best understood by examples. It's the content of whatever you're interpreting. So in a criminal case, it's the type of crime. Is it a rape or a robbery or a theft? And the civil system's counterpart to that is what we call a cause of action. So you think crime in the criminal case setting, cause of actions are in the civil, and that cause of action might be for negligence or for a breach of contract or for property. Okay. So it's quite complicated, but you need to have a general understanding of the legal system, both procedurally and substantively. Also, understand the interpreters need to know the protocol, which can be expected of the different parties or the legal players in the system. Again, this applies both civil and criminal cases. So you need to know what the judge does. You need to know that there's 3 kinds of clerks and you get different information from different clerks. So if you need a file, you go to the file clerk. You need to know if you need to check in, you go to the courtroom clerk. If you need to talk to the judge, you might go to a law clerk. So the bailiff, obviously, knowing what the various different actors or parties in the criminal system, criminal and civil system. So a general understanding of both of those systems, as well as understanding specialized courts. So the types of crimes that might be, and the punishment associated, oftentimes those are very, very local, and you'll have the same concept, but it was given different cute names in different places, or it'll be named after a case, or it'll be abbreviated according to the statute number. So a VOP, V as in Victor, yeah, O, P as in Paul, sorry, is how we abbreviate a violation of probation. And the common guilty plea, and if you plead guilty, you go to AA, and then you come back a while later, and then your case is dismissed. Well, we call that a 641. So you might go into court, and the judge says, "Why are you here?" And the lawyer says, "We're here for a VOP on 641. Right? So every local court, every county court, every court of what's called general jurisdiction are going to have their own kinds of abbreviations, and the absolute best way to learn that is to be exposed to it and to talk to your colleagues about it. So you want to know the types of crimes and punishment. Is it an arson? Does your state have various degrees of assault? Do you understand the differences between burglary, larceny, robbery? You don't necessarily need to have to understand all of the differences, but you have to recognize the words, and if they are going to be an issue in the case that you're in, you would need to find out what they mean, look them up. So you also need to know about the procedures or proceedings that you commonly encounter for example, in the criminal system. There are a lot of different types of hearings. There is the grand jury process. There are motions hearings. As I already mentioned, the arraignment. There's jury trials. There's bench trials. when a person is arraigned, they enter a plea. When they plead guilty, they change that plea. So in your state, it might be called a guilty plea hearing, but it's more likely called a change of plea hearing. Sentencing, violations of probation, revocation of probation. Then you also have to have a general understanding of the civil system, the various common causes of action. And I mentioned some, but they're commonly the breach of contract action. You might find yourself in a consumer protection action, fraud, malpractice, wrongful death, and understanding the general processes involved in civil cases because they're different. For example, discovery is a common word that has a very specific meaning in the civil litigation field, and that is, it means it's an exchange of information pre-trial, and it involves sending written questions to the parties, asking for documents, and deposing witnesses. So the written questions are called interrogatories. Depositions, you have to understand what kind of a procedure that is, and depositions are very sensitive. So because essentially a deposition is witness testimony that happens in a law office, but there's no judge there controlling the proceeding, so you get not always the best side of the attorneys. It's also important, both in the criminal and civil settings, to understand jury selection and where the deaf juror's role falls in that process. And what is done to become a juror is a process of questioning called voir dire, V as in Victor, O-I-R-D-I-R-E, unless you're in the South, and then it's voir dire. So that was for Austin. Yeah, so in both civil and criminal cases, the jury selection and the deaf jury is important to understand. It's also critical to understand the importance of the record and how the record is used to define future case law, and how it is that at times sign language interpreters have to make a record themselves. So for example, one of the protocols is that we speak in the third person always, unless we're interpreting. So if I need to make a record, I would say, Your Honor, the interpreter requests a clarification, or the interpreter needs a break to maintain the accuracy of the interpretation. So I'm actually making a record so that gives the judge a chance to decide whether or not I get to take my break or get my clarification. And if he doesn't, then it's typed down in the transcript so that an appellate court can determine whether the judge was wrong or right in supposing he denied my request. So the record's a critical part of the court interpreter protocol. Court interpreters also need to know the implications, the legal implications of privileged communication, and those apply to both courtroom interpreting and to legal as well as quasi-legal interpreting. So there are a number of specialized courts, and the interpreter needs a general understanding of the specialized courts as well. So there are specialized courts are called courts of limited jurisdiction. The legislature creates them and tells them what kind of cases they can hear. So these will be state-specific, sometimes probably even county-specific maybe. So you might have a family law court, a mental health court, drug court, traffic court, and then mediation is not really a court proceeding, but it is definitely a legal setting in which, prior to going through the time and expense of a trial, the parties will typically meet with a third-party mediator, and the mediator will try to gently persuade them to come to an agreement so that the trial can be dismissed and everybody gets some of what they wanted. So it's important to understand those processes. And mental health court, mental commitment proceedings are very complicated and require the use of a deaf interpreter. At least best practice would suggest that a deaf interpreter would be required. Finally, the legal interpreter needs a general understanding of law enforcement, and that includes methods of reporting and investigating crimes, arrest processes, what and where happens when a person is detained and booked. In one of the courts that I work in, a person can be summoned to court by a paper, a summons sent to their home. And so the person's never been arrested, has never been administratively processed. And so they show up and they might plead guilty. It's maybe the very first time they've shown up. They've pleaded guilty. And the case is resolved. It's over. And then the judge sends them across the street to the sheriff's office where they are then booked. So I think that a layman's understanding is that, well, booking happens at something at the beginning of the process. Booking is something that happens at the beginning of the process, but it can be at the end. So, excuse me, the interpreter needs to have a general understanding of Miranda and when it is used, and the legal ramifications of interpreting from Miranda. It's important to know when separate interpreters are going to be needed for suspects as opposed to witnesses. It's also important to know when the interrogation or the interview has crossed the line to where it's no longer a general witness interview and it becomes an interrogation, and the person then is required to be Mirandized. I think I'm on the next slide. Let me just check something. No. All right. Okay, so another domain area is that of legal theory, knowledge of legal theory. Right. So you don't have to be an attorney, but you do need to know primarily that legal theory that applies to interpreters. So we've got, most states have their own interpreting legislation and or regulations governing who can work in court. You need to know what that is. You need to know if you're qualified to work in court by the court's own statute. And then there's federal interpreting legislation that applies to all language interpreters. Some of the legal theory that has been interpreted extensively with respect to interpreters is that of privileged communications and what to do if you're subpoenaed to testify and how to make a proper response. There are evidentiary rules that affect interpreters. They've been created for how interpreters can interpret, which interpreters can interpret, and those are important to understand as well. The general process of an appeal, and I've already explained what that essentially looks like. There is a legal standard of a reasonably competent interpretation. So if one is interpreting for Miranda and the defense attorney files a motion to suppress the confession based on a substandard interpretation, which happens frequently, then an expert may be hired to review the interpretation or to have the interpreter reinterpret it so that it can be viewed if there wasn't a video, and determine if that was a reasonably competent interpretation. A number of cases have talked about the due process tests for when an interpretation makes the criminal process fundamentally unfair. And there's also legal theory in terms of immunity for proceedings interpreters, similar to for witnesses, judges, etc. That affects our practice. Protocol. Protocol is, as I mentioned earlier, conduct, stuff that's different. The Court Interpreter Code of Ethics sets forth what a conflict of interest is. And it may be different from the RID's conflict of interest, and it likely is. So a conflict of interest deals with a relationship. In other words, you know the person you're interpreting for, or you have some kind of financial interest in the case. Those are the most severe conflicts of interest, but they don't always require that you, well, if you have a financial interest in the case, yes, you don't interpret the case. But there are other kinds of conflicts where if you know the person but not reasonably well, then you don't have to decline the case, but there is a process of disclosing to the court on the record that you have a relationship or you have a prior contact with any of the parties in the matter. So protocol knowledge. We're defined also as an officer of the court. So interpreters have to know what that means, and not only know what it means, but know what the scope of that duty is. So it's narrow. It's not, an officer of the court is anyone whose loyalty is primarily directed to the court. And that's true for us with respect to providing a competent interpretation. But the scope of the duty is very narrow. We aren't responsible for everything that happens in the courtroom. We're just responsible for ensuring that we accurately and competently abide by our oath to interpret all of the proceedings accurately. There's that word again, voir dire. So what that means is there's a rule of evidence on interpreters, and it says that interpreters will be qualified as if they are expert witnesses. When an expert witness wants to give an opinion, they first have to answer a series of questions about their expertise. So we know that, in fact, they know what they're talking about. Well, interpreters at times have to also be voir dired, or you'll hear it called qualified. Or they might be interpreting the qualification process for a deaf expert witness. So voir dire proficiency is important protocol knowledge to have. It's so important, as we'll see, is that the RID has it on the the SCL examination. Both the interpreter personally being voir dired and the interpreter interpreting for the voir dire of a certified deaf interpreter. Other protocol knowledge, proper modes of interpreting. The Federal Court Interpreting Act sets forth that the proper mode of interpreting when there's a non-English speaking witness is in the consecutive mode. So probably nobody out there is as old as I am, but we weren't trained in the consecutive mode. So that means we have to get comfortable doing it. And not only using consecutive interpretation, but also note-taking. It can be done. I've seen it done very well. But it can't be done very well unless it's practiced. Because it's frankly hard to watch somebody signing and to write anything legible on a piece of paper at the same time. But it can be done. We already, proper modes of interpreting that I mentioned was consecutive interpreting, but there are also times when simultaneous interpreting would be used. And there are times when we do what's called sight translation, which is reading a document from English and interpreting it into ASL, or watching a deaf person sign something and writing it down into English. So that's sight translation. We already talked about speaking for the record. We use the third person. There are a number of roles. We call them proceedings interpreters, table interpreter, or access to counsel interpreter. And then there's the function of witness interpreting, and there are also jury duty interpreters. So there are various roles that we play, and the specialist needs to know what they are. Placement is an issue because we have a visual language, and that we're not permitted to block the view of the judge to a witness or the jury to a witness. Yet we have to be standing directly in the sight line of the person that we are interpreting for. So placement sometimes becomes an issue. The other sightline issue that comes into play is if there is an interpreter sitting at the table to facilitate communication between the attorney and their client while the court interpreters or proceedings interpreters are working, want to make sure that that communication is protected. So if there are deaf people in the audience, you would want to have a screen behind you. If there was a deaf witness and a deaf party, then somehow that sightline has to be impeded so that the privileged communication maintains its protection. Know the security protocol for wherever you're working. In our local court last week, they sent around a notice saying that they were having an active shooter training, and that if we wanted to, as court interpreters, we were more than welcome to go get trained on what to do with an active shooter. Good time. Responding to subpoenas. Court interpreters need to know the correct protocol. Court interpreters need to know the correct protocol for responding to subpoenas. After you freak out, you could freak out, and then you call the RID, and they'll tell you what to do. Another of the domains is interpreting knowledge. It's important to know the historical legal basis for court interpreting in your state, because you use that legal basis to be able to clearly and logically articulate the role and function of the court interpreter, should you need to justify or interact with the court or interact with the clerk or interact with an attorney. It's also important to understand the discourse structure of legal texts. And there are characteristics of legal language that are studied in almost every legal interpreting program, from using complicated sentence structure to using common words, but using them with an uncommon meaning. And there are good articles that are written on that, that are available on the RID website in the information that's presented for people who want to take the SCL. There's a reading list. The discourse structure of ASL legal text. Interpreting knowledge includes the ability to assess your skills accurately, as well as determine the type of interpreting and the appropriate register that's needed for the specific site setting. Interpreters need the ability to articulate, it's English, the ability to articulate for a deaf interpreter specialist. So in a manner that that is appropriate. Oftentimes people will say, I need a deaf interpreter, and then the court will question their competence. So we need to have a way to make that articulation clear and cogent for the court or for whoever's hiring the interpreters. Interpreting knowledge includes the ability to advocate for and work with a team interpreter, whether deaf or hearing team, and the ability to hire for, to argue for appropriate hiring practices, to make sure that all of the deaf parties involved, whether they're the witness, whether they're the defendant, the witness, the plaintiff, or the audience, has access to the court and proceedings and the related communication. Continued. The ability to obtain salient case-related documents and the information necessary to not only prepare yourself to interpret accurately, but to make the whole process more efficient for the court so that you can determine who are the people who have been involved before you leave home to determine whether or not you have a conflict of interest for which you shouldn't take the job. So that means getting the case file. It means getting the witness list. Some of it's online, depends on your state. If it's federal, it's all online. And then knowing what to look at if you have limited time. So what is in a case file? What can you expect to see? That's important to be able to prepare accurately. Interpreting knowledge involves having the ability to make ethical decisions and to understand the effect of those decisions on the legal interpreting process. Already mentioned, it involves the ability to competently use consecutive interpreting, note-taking strategies, simultaneous interpreting, sight translation, understanding that consistency in staffing is very important, but sometimes it's not permitted. So that's when the courts have made the determination that the interpreter who did the Miranda warnings is likely going to be a witness in the trial. So it's not efficient or effective to have that interpreter also interpreting the proceedings. Right? So there are certain parts of staffing in legal settings and in court that aren't consistent with best practices outside of the legal setting, and consistency is one of them. Knowing when it's important and knowing when it's not, or it's not possible. So knowledge of hiring practices and business practices within and among the various courts that you work with. So that means having written contracts when required for your services. Understanding the appointment process in various courts. And appointment in that sentence means how you are formally constituted as the court's interpreter. And oftentimes it doesn't happen until you're sworn in, and then you will have been, quote, appointed. And then adhering to standard practices as any independent business person would do in a consistent and ethical manner. So finally is the professional development knowledge competency. Legal interpreters do have a strong commitment to ongoing advanced knowledge and skill. The law changes all the time, so our understanding of it will change as well, which means legal interpreters have to be committed to lifelong learning. And again, if you just take a look at the awesome list of 156 people that are on this webinar, you will see people who have as much experience as I do, some who have more, and some who are brand new. But that's because there is a commitment to always learning, sometimes relearning, but continuing to develop your knowledge and skill. So I'm going to ask people to stop talking privately to each other so that I'll be able to see the questions, that if you have any questions regarding the competencies, I'd be happy to take them now. Really? You guys are talking a lot to each other. Yeah. Great. I'll give you a moment to look over your notes. Ira, I can't answer your technical questions. You'll have to address them to the center staff. Josh is the person who would know. Kirk asked about articles or tips for note-taking and consecutive interpreting. I saw somebody post the link in the chat box to an article written by Deborah Russell, and she has a number of different articles. I'm not sure which one that was, but she did her PhD in consecutive interpreting. In terms of note-taking, there is, I'm going to spell the name if I can remember it. Oh, okay. It's the Rozan, R-O-Z-A-N method. If you Google Rozan method, you'll come up with this one article that is the Bible for spoken language interpreters. If you Google note-taking, you will also come up with court interpreter note-taking with a master's thesis done by an Asian gentleman, and I apologize, I don't know if he's from which country he's from, but it's written in English, and it's also a very good article on note-taking and consecutive interpreting. Daryl, congratulations. I knew that you graduated, and I was going to jump in earlier and tell you that from everything I know, the California bar is supposed to be the hardest in the world. Well, right up there with New York. So good luck with that. And I don't know you as well as I used to when you lived out here, so it's really hard for me to tell you where you should focus. But when I took the examination, or you're not talking about for the examination though, you're just talking about in general. I think in general for everyone, you can't get this in a drive-by. You have to actually be exposed to it over and over and over. And interpreting law school is a good way to do that, but that won't get you what you need in terms of really practical everyday being in court. I would observe. I would go and observe court proceedings. I would talk to lawyers. I would talk to judges. I know when I was in law school, we got an appointment with one of our local judges, and he gave us an hour or so of his time on evidence, which was also exciting at the time. But having those systems, excuse me, I need a drink of water. Having those systems in place to get the support you need from a more experienced court interpreter, an attorney, and a deaf person for a qualified deaf person for language issues is key. Sure. Hi, Anna. Anna's asked about the question about consecutive interpreting and why notes would be needed. and she wanted me to expand a bit on that. I didn't see that question. We use notes as an aid to memory. They help us in supporting our short-term memory when we're using consecutive interpreting. So in consecutive interpreting, there will be a period of your source language that during which time you are storing it in your short-term memory, and you're also using other aids like your schema and your real-world experience to be able to help you recall that message. And note-taking is just a way to do that. So it works in tandem with your short-term memory. It's not a transcript. It's not shorthand, but it's just an aid to help you remember. And the key, I think, is to make sure, at least in the beginning with consecutive, that you have short enough segments where you can really develop your short-term memory, and you're not getting so overwhelmed with oncoming source language that not only can you not take notes, but then you can't remember anything. So the goal would be to have short chunks or segments of information, and with the goal then of lengthening those, and notes is a way to do that. Hi, Jerry Ann, I'm looking at yours. One of the most difficult issues for me is knowing how to interrupt or interject with the court. Can you give us some pointers? There are, well, first of all, I will say you should do so politely. And you may have established it ahead of time. You may have had a meeting with the court and suggested that if you raise your hand, the judge will know that you have an interpreting issue that you would like to have the court address. One thing that you can confidently do is try to gauge what attorneys do. So an attorney wants to talk to the court, he or she might say, may I approach the bench? May we approach the bench? There were a number of things that were going through my mind, but I just think, there's another phrase that's frequently used if you need some time to complete an interpretation, or if you're interacting with the deaf person after you've received permission and you're getting a clarification, you can say court's indulgence with a question intonation, and that essentially is a polite way of saying I need a bit more time, Judge. So, but, polite but confident. I mean, you have taken an oath to interpret accurately, and if there's a need that is, if it is indicated that you need to interrupt or interject in order to competently abide by your oath, you have an ethical obligation to do so. And in courts that are members of the National Center for State Courts, Consortium for Language Access, they have a code of ethics that specifically says you are able to interrupt and interject. So know that it's not just you. I mean, you've got the people who wrote that code of ethics behind you, and that should give you whatever confidence you need. There's a question, are you going to go back to the Miranda piece and the parts you kind of talked about around that? Or was that like a preview and you should look to it on your own? Well, we're exactly halfway through and we have 20 minutes left. So the Miranda is a really important, it's an extremely important law, it's a case law. Miranda versus Arizona, and there are a number of good material. There's at least one very good videotape about Miranda out, and I would highly recommend that you look at that. It's produced by Sign Media Incorporated, and it's most likely called the Miranda Warnings, but you will find it if you go onto their website. Okay. Yes, I think I've responded to Daryl's question. And what I would recommend everyone focus on is actual exposure, by going down and learning the language of the court by experiencing it. And Amanda Mueller. One question I have regarding the readings, some of them were published more recently, but the RID test is from 1988. I wonder if some new information might conflict with the way we should answer the test, and if so, any recommendations on how to navigate that while we are learning for our practice. First, I don't know that the test is from 1988. I think that it's earlier in the 90s, but your point is well taken. It's difficult to know everything that's changed if you weren't in the field back then. Many of the principles are the same, but then some of them are different. For example, it was one of the articles that they suggest you read deals with deaf jurors, and it was written before the ADA was passed. So we didn't really see deaf people on jurors prior to the ADA being passed. I don't know that, I think a study group is probably to talk about this issue. It might be a really good way to try to figure out how to answer the questions in a way that is acceptable, even though things change and knowledge and learning continues. Okay. Steve Finn has asked, this is the last one, and then I think I just want to go quickly through what's on the RID exam so that we can get through this and hopefully have a little bit of time at the end. So Steve asks, can you talk about site translation forms? I understand the need for providing site translation, but I worry if the deaf person will view me as a legal expert. I feel more comfortable if the lawyer or court personnel read the form aloud in chunks to allow for consecutive interpreting. Steve, I understand that need or that feeling of you're hearing and you're a court interpreter. I don't know if you guys can hear my cat, but she's just cute. So if you hear her screaming, I'm not beating her. I don't beat her all that often. But I wouldn't do it while I was on a webinar. So I understand that deaf people often, first of all, just feel like because you're hearing, you have more information, you know the answer. But now we're in court, and you're a legal interpreter, and you've taken a test in it, and you really need help with them. So I don't have an issue if it is read and then interpreted consecutively, except to the extent that there may be times where you really need to move some of it around on a larger discourse level. For example, it doesn't work with Miranda. Miranda's only 5 sentences long, and it may be that you need to move them around in order to make the content clear. For example, you might want to put the right regarding a free lawyer first, because if the deaf person is thinking they have to pay for an attorney, they may not be able to focus on anything else if they don't have a lot of money. So that would be my response. Okay, so let's move quickly through this next session. The path to specialization is the specialist certificate legal. There are eligibility requirements to sit for it. There's a written exam and an interpreting examination. This is going to seem a little bit strange, but when I looked at the RID's website, I saw these various ways to sit for the examination depending upon what your educational background is, and I thought this must be out of date. So I contacted the RID, and in fact it is not out of date. There are different eligibility requirements to sit for the written examination as compared to sitting for the performance examination. These eligibility requirements come in categories, and these are valid to sit for the written test. But then you have 5 years to get your bachelor's degree and to take the performance exam, or your pass on the written test will expire. So you have to have an associate's degree or alternative pathway. Category 1 is you are a certified member of the RID. You have a bachelor's in any area or an associate's degree in interpreting, plus 50 hours of legal interpreter experience and 30 hours of formal training. Category 2, again, you're a certified member of RID, and you have only an associate's degree, but it's in any field. So in this case, we increase the number of hours to 75 of interpreting, and we increase the number of hours to 50 for legal interpreter training. Category 3, certified member, and obviously I created this PowerPoint before I talked to the RID, but you can sit for the written exam if you are certified and have no degree, but have 100 hours legal interpreter experience and 70 hours legal interpreter training. And then finally, if you really like tests, you can knock yourself out and do it again. So that's for the written exam. The domains of the written exam tests are categories of language, judicial systems, team interpreting, and professionalism. 25% of it is on language. So because we're running out of time, I'm going to let you read these, and I'm not going to expand upon them. Okay. 40%, which is why I say exposure, exposure, exposure. 40% of the exam is on the judicial system, law enforcement, including Miranda, procedure, logistics, both the criminal and the civil system, as well as the specialized courts that we talked about earlier. And again, interpreting statutes, regulations, and the rules. Team interpreting is 15%, and it includes both with another interpreter who can hear and with one who cannot. Professional issues, we've talked about these in the competencies, so that makes this goes a little bit quicker. State and federal legislation related to or governing interpreters, legal interpreting ethics, and liability issues for interpreters. The performance examination, or the interpreting exam, has 5 parts. There's a Miranda warning that will be interpreted. It's a sight translation. And the people who were on the committee who created it, while it is old, they were very smart and they were very committed people. So they said you may interpret several, be prepared to interpret several renditions. And that's exactly what it means. It doesn't mean be prepared to transliterate one and to interpret another. The second part of it is a courtroom scene, which includes deaf witness testimony, motions, objections, and a bench conference. And it also includes other things that they don't list. They just say among, including but not limited to. Then, as I mentioned earlier, the interpreter candidate interprets the voir dire of a deaf interpreter, and then personally undergoes voir dire as a candidate. And finally, jury instructions are interpreted. They say, the test instructions specifically say that interpretation is expected in the Miranda warnings, the courtroom scene, and qualifying the deaf interpreter. That transliteration is accepted only in jury instructions. Okay. So that's the exam. I know that there are a number of online SCL prep courses available. I think Lynn Wiseman is online, and she has one through her company. And there are also people who do SEL prep in person. And as what I'm going to talk about next is LIMS, which is the Legal Interpreter Member Section. We hosted a day and a half SEL prep examination at the 2009 RID conference. So there are ways to get that information, or to get more prepared, to feel more prepared for it. So on to resources. The RID Legal Member Section is extremely robust. They're kind of loud, but we have a wonderful listserv that's been in existence for many, many years. We also, and if you join at that website, you'll be able to access the Yahoo listserv. And for a discussion of that ongoing collaborative, reflective analysis that we talked about earlier, a lot of it happens on that listserv. We have meetings at RID conferences. We have interim activities, workshops, or pre-conferences. And so that's LIMS. It's free to join. You don't have to be a legal interpreter, but it's a great place to connect. And as I've said over and over, the Marie Center is the Center on Excellence in Legal Interpreting, and who brought you this free series. There's their website, and it has all of the documents and products that over the past number of years that they have had the grant that we have been published. There is also the 18-month legal interpreter preparation program to get that exposure, right? And the Institute for Legal Interpreting is a national conference. It's usually every 3 years, and depending on what's going on with Iron Sharpens Iron. And our next one is in May of 2014. I know that there will be announcements, but it's going to be on deaf hearing teams in court, and it's looking to be a very exciting program. So hope people have a chance. It's in May of 2014. NAJIT, or NAJIT, I'm not sure how to say it, is the National Association of Judiciary Interpreters and Translators, spoken language professional organization for interpreters. And then I also mentioned earlier the Consortium for Language Access. This is something that is a part of the National Center for State Courts. And they have this consortium. They're very interested currently on expanding the scope of interpreting services in all languages, and in particularly in civil areas. So I got that through. I got through that in a remarkably short period of time. So we have 8 minutes left. If there are any final questions, I'm happy to take them. I know that Carrie White needs a few minutes at the end, and I'll scroll down. Colleen McKerney asked an excellent question. And she says, I'm brand new to the idea of court interpreting. Are we allowed to sit in court to better understand the proceedings in the protocol? Yes, you are. Indeed you are, and I recommend it. Go as often as possible. Very few proceedings are in private. If they are, and it depends on the state, it may be a juvenile matter or what we call a termination of parental rights, where they permanently adopt children out because parents aren't able to take care of their kids. There may be some cases that might have a protective order in place that closes them. You can even listen to the United States Supreme Court online. You go to, it's called SCOTUS, S-C-O-T-U-S, S-C-O-T-U-S, Supreme Court of the United States. .blog or .com, SCOTUS blog. If you go there, they have taped the appellant arguments, but it's probably not the best place to start for what you really need right now. And what you really need right now is to go see what they do in traffic court and see what they do in divorces in your state. because that's where you're going to be interpreting the most. Okay. Let's see. Question, Glendia, are your notes subject to confiscation by the court, lawyers, etc.? Yes. So don't write derogatory things about the judge. They are. I've never actually, in 30 years as an interpreter and 20 years as an attorney, I've never seen it happen. I've seen fights over the deaf person's notes when they were taking while they were in court, primarily because there was an argument as to whether or not they understood English, therefore needed interpretation. But I've never seen them take an interpreter's notes. Okay, Helene, I believe Ms. Schley was asking why we would write down what a deaf person was signing. Why would it not be voiced? I was speaking. Okay, sure. That's a great question. At times, particular for domestic violence proceedings and for financial affidavits, if the deaf person doesn't use English, then I will interpret the form to them. They will interpret it to me, and I will write it down. I will fill it in. That's sight translation going from ASL to English. That's clear. Okay, there's another question about sight translation. And I think I expanded on that with Steve. So I know that Carrie needed to jump in here for these last 4 minutes. So I'm going to thank you all very much for your time. And we really appreciate the Murray Center giving us the forum to do this. And I look forward very much to the next 4 in this series. So thank you very much.
Carrie, are you there?
I'm waiting for Carrie. Well, Carrie's here, but her talk button isn't. So we're working on this technical issue, and I know she needed to give you some information and instructions on CEUs. And while I have the floor, I got a private message from Glenn Bennett, and I know that he had. Sorry, there was something with my volume. I won't be able to say that. I will find. Great, thanks, Anna. If everyone can take a moment and look at the chat, they will be sending information out on how to follow up with the CEU process. Everyone have a good night.